Hello dear CMA aspirants from South India. As you all already know, Akash Agarwal Classes has launched for you all 100% English lectures in English for CMA Foundation students giving their examination in December 2025 and onwards. So here I am going to tell you how do you enroll in the batch. You just have to join our WhatsApp community, which is given in the link. Fill up the Google form again given in the link, and to download our mobile application Akash Agarwal Classes to access the notes. You all know the lectures which we are going to conduct will be 100% covered. There would be no subject which we are not taking care of. So we are going to take care of each and every subject, each and every concept. We are going to take MCQs for you. We are going to provide test papers. We are going to take live mentee sessions as well. Lectures which we are going to take for you all are 100% recorded lectures and not dubbed lectures. And you all know we have exclusive team ready for you all to teach you for your CMA Foundation December 2025 attempt for subject wise as well. And we are uploading the lectures on a weekly basis. All the important links which will be useful to you all are uploaded in the description box. Since we have many students who have cleared CMA examination at all the levels from Akash Agarwal Classes, and to reciprocate the love which we have received from South Indian students, we are here for you all taking lectures 100% in English, so that we can clear your CMA Foundation December 25 attempt together. So keep studying, do watch all the lectures till the end, and do show some love by liking the video, subscribing to the channel, and putting up a word in the comment box. Keep studying. Bye-bye.
Hi everyone, very good evening people, good evening gang, good evening guys. So I am CS Kajalande, and today we will be covering the second last lecture of SOGA. So there are these two different provisions that we'll be covering in today's lecture, and as I say, they are not very difficult and not very easy at the same time. This is something that you guys will enjoy studying, no doubt, but at the same time you guys will also like this part because it's pretty easy. Not pretty easy, I wouldn't call it very easy the way conditions and warranties was, right? If you saw the lecture of conditions and warranties, that was so simple, that was so easy. So if we talk about today's session, it's going to be not bad. It's going to be understandable by you, okay? So yes, let's start people. Let's start with today's session, but before that guys, do not forget that we have provided a link in the description. You guys will get all the notes, you guys will get all the updates about the mentees and quiz and this and that, everything you will be getting in the link itself. Okay, so please just go click on the link and download everything from there. Okay, so yes guys, let's start. Now, what are we going to be covering today? So, now, this is basic, right? The concept that I'm going to ask you, it's very basic. Who can do a sale? Who can do a sale? A person who is an owner, or a person who is a non-owner? Who can do a sale? Obviously guys, even like let it be anything, even if you talk about human tendency, even if you talk about human relationships, when do you have all the rights on a specific person? When you are committed to that person, okay, that is a time when you have all the rights, when you have complete rights related to that specific person. So this is what ownership is. So if you are an owner, only then the sale will be valid. But twist, breaking news. As I always say, there's always a twist, there's always a breaking news when we talk about, when we talk about our SOGA, it's not less than a movie. There's always some breaking news, there's always some twist in the story that we have, right? So, if you talk about a person being an owner, if you talk about a person being a non-owner, obviously you are going to buy goods from a person who's the owner of that goods. But, in certain situations, even the non-owner, who is not the only owner, or who is not the actual owner of the goods, can also make a valid sale. Understood? Once again, generally what happens, an owner, he is the one who is authorized to sell his goods. But in certain situations, even a non-owner can go ahead with the sale of his goods. Okay, in certain situations. Now we are going to see how. We are going to see in what all cases. So the first case, first of all, only an owner can sell his goods. Okay. Now this term which you can see, nemo dat q habit. Now what do you mean by nemo dat q habit? Nemo dat q habit means only a owner can transfer property. Only a owner who owns goods, okay, the real owner can decide what to do with his property. He has all the authority. No one else other than him can transfer the property. Okay, this is the term nemo dat koi habit. Please remember this from MCQ point of view. What do you mean by this? That no one can give what he himself doesn't have. What we only don't have, how can we give that to others? Not possible, right? Okay, now just hold on, everybody, hold on. Okay, now, number one, sale by a person who's not the owner. So number one is mercantile agent. Okay, so if we talk about a mercantile agent, now I am simply going to be explaining all these concepts to you just by using an example. I'm not going to use many technical terms. I'm not going to complicate it. I'm going to give you examples and I'm going to explain the concepts to you. Simple, okay? So now he is Pushpa. All right, he is Pushpa. This one is Shiva. They both have good amount of hair. Okay, so Pushpa and Shiva. Shiva, he is the owner of these goods. Okay, he is the owner. Who is the owner? Shiva. He is the owner of these goods. He has gone to London for a trip with his family. Now, till then, he says, Pushpa, you be my agent and sell these goods for 1 lakh. Got it? He said he authorized him to sell his goods. And and for what amount will the goods be sold? The goods will be sold for 1 lakh. Pushpa says, okay. Now this guy, Shiva, he leaves. He's gone to London. Now this is a different matter. Okay. Now here, if we talk about Pushpa, there is another person. Let's consider the name to be Shrivalli. Shrivalli. Okay, so this Shrivalli girl, a very pretty lady. Okay, so we are going to, I'm going to explain all the concepts to you of the sale by non-owners using these 3 characters itself. Okay, so now Pushpa goes to Shrivalli and he says that, you know what, I have these goods. Do you want them? Shrivalli says yes. So Pushpa sells these goods for, let's consider 80,000. Okay, for how much did he sell it? He sold it for 80,000. He, of course, looked at Shrivalli, he fell in love, he looked at her eyes, he looked into her eyes and he was like, it's okay, I don't want to sell these goods at 1 lakh, I'll just sell it at 80,000, and he sold it for 80,000. Okay, done. Now, when Shiva came back from the trip, he just got to know, oh my God, my goods which were worth 1 lakh, they were sold for 80,000. So Shiva runs to Shrivalli and he says, give me back those goods, I need the goods back. Will Shrivalli be bound to give the goods back? No, because Shrivalli had done the transaction in a good faith. Right? So whatever Shiva wants, he can recover it from Pushpa. Fine, that is their internal matter. But the sale that has been done by Pushpa, who is a non-owner of the goods. Was Pushpa the owner of the goods? No, he was a non-owner. So the sale that has been done by Pushpa, the sale that has been done by the non-owner of the goods, that will be valid. Understood? Generally, what do we say? We cannot sell something that we don't have. But here, Pushpa, he also did not have the ownership of the goods, but still the sale was valid? Yes. Got to know how? Okay, now, this is done, mercantile agent. Now, second one is by joint owners. Now, what do you understand by joint owners? So, let's delete few things. Why did I delete Shrivalli? Okay, now, Mr. Pushpa, he is the owner of the goods, even Shiva is the owner of the goods. So these two are co-owners, okay? They are co-owners, means both of them are owners. Now, we of course have this pretty little lady here whose name is Shrivalli. And in such a scenario, Shiva, he went to London for a trip. Pushpa, he went to Shrivalli and he sold these goods. Again, these goods were of 1 lakh, but he sold it for 80,000. Now, is this a valid transaction? Absolutely. Though, even Shiva was the owner, even Shiva had all the rights to be a part of this transaction. But Shiva, when he comes back from London, he can't go back to Shrivalli saying, I am also the owner of these goods. My consent wasn't taken. They are the joint owners. So obviously, Shrivalli is going to consider, or we assume, that the consent is there. And they are the joint owners. So both of them have the authority. So we assume that both of them are equally involved in this kind of a decision. Okay, so Shrivalli has done this transaction in good faith. This is very important, guys. The transaction must be done in good faith. Now, you all know what good faith is. Okay, so this transaction is done in good faith. So this will be a valid transaction. Okay, next we will be talk about a person who is in possession of goods under a voidable contract. Now, again, the same 3 people that we have, okay? Okay, so this is Shiva, this is Pushpa. Okay, we have Pushpa here, we have Shiva here, and Shiva was the owner. Okay, who was Shiva? He was the owner of these goods. Okay, Shiva, he was the owner of these goods. And he sold it to Pushpa. Pushpa did this transaction. Please remember this. Listen to the words I'm saying. Now, because you've been attending Indian Contract Act as well, so you know what a voidable contract is. It can be cancelled at the part of the aggrieved party, correct? The party with whom something wrong has been done. So now, Pushpa, he obtained these goods by fraud. Okay, he did a fraudulent transaction with Shiva and he obtained these goods on the basis of fraud. Okay, or else let's consider. Yes, that's it. So Pushpa has done a fraud and he obtained these goods. Okay, now after doing this fraud, he forwarded these goods to Shrivalli. Shrivalli did not know anything about this fraud that was done between Pushpa and Shiva. She did not know. She bought the goods in good faith. So now when Shiva realizes about this fraud, he being the owner of these goods, he cannot run to Shrivalli saying, give me back my goods. The goods that the transaction that you did was fraudulent. And that is absolutely not Shivalli's problem. She say, I have done the transaction in good faith. I did not know the goods are fraudulent. I had no idea about this. Okay, so here, Shiva can recover it from Pushpa. Of course, it is their matter. They can deal with it. But. Pushpa, being the non-owner, he was not the owner of these goods because he had obtained it by fraudulent means. This contract was voidable at the option of Shiva. Okay, but still he did it. Still the transaction was forwarded. So in this kind of a transaction, we will still say, once again, that the non-owner will be it will be acceptable even if the non-owner makes such a sale. It's going to be a valid sale. Got it? Then next, seller or buyer in possession after the sale. Now, so Pushpa and Shiva, Pushpa and Shiva, these are the goods. Shiva is the owner of these goods. So let's consider he becomes the seller now. Okay, so he becomes the seller. Pushpa becomes the buyer of these goods. So Shiva, he sells these goods to Pushpa, but then the possession is still with Shiva. And then walks in Srivalli, a beautiful lady with a beautiful smile, nice long hair. And she walks in the shop and she says, oh, you know what? I want these goods. Now, they are in Shiva's possession. Now, you guys very well know what is the difference between ownership and possession. So they are in Shiva's possession. They are not in his ownership. They are in his possession. So Shiva has these goods in his possession. Okay? He's not the owner. The owner is Pushpa. Correct? Shiva has just kept the goods on his behalf. But when Shrivalli walks in and in his shop and she sees that, oh my God, what a beautiful goods. I want these goods. So Shiva's heart melts. He says, "Jhukega nahi sala," but that was Pushpa's dialogue, I know, but then we'll just keep it for Shiva for now. So then he says, "Jhukega nahi sala," but then I jukofied in front of Shivalli. He melted. His heart melted in front of Shivalli, and he gave away this property to Shivalli. He gave away the goods to Shivalli. Okay, now in such a situation, guys, it's clear when the properties, when the goods have been given away, he was not the owner, he had just the possession. But still, will this be a valid sale? Absolutely. Because did Srivalli knew about the first sale? Was she aware of it? No. She had done this in a good faith. She was not aware about the first sale. Clear, everyone? Yes. Okay. Now, this is done. Now next, sale by estoppel. Now what do you understand sale by estoppel? Pushpa, Shiva, he was a seller and Pushpa was his agent, not a declared agent, but when Srivalli went to purchase certain goods, Pushpa said, talk to me, I am the agent of Shiva. And Shiva heard that and he was silent. He was just there. He was silent. He did not deny it. Now, when he did not deny it, obviously Srivalli assumed that Pushpa is standing here. Shiva is standing here. Pushpa is telling me that I am his agent and Shiva is also just standing there saying nothing. So obviously, they are on common grounds. They agree to this particular thing that yes, Pushpa is the agent. So once Pushpa sells something to Srivalli and then later on Shiva cannot go running to Srivalli ki no, this was not allowed, he was not my agent. Srivalli will obviously question, why didn't you say something that time? Why were you silent that time? Correct? Yes, guys? Okay. So that is by estoppel, then sale by a finder of goods. Now what do you mean by finder of goods? For example, Shiva was just walking by, okay, and he found certain goods. Shiva was walking by and he found these certain goods. They did not belong to anyone. He did not know the owner of these goods. Then of course, we being Indians, typical Indians being Indians, we need to know what happens, okay? So we opened, fatafat, we opened the box, Shiva opened the box, and he saw that there were fruits inside it. Now he cannot keep and conserve the fruits for n number of days, right? They are going to get spoiled within 2 to 3 days. So these fruits were there, which were not, which might get spoiled. So that's why Shiva, what he decided to go and he decided to sell these goods. Okay, so he can sell these goods. He's not the owner of these fruits, but can he still do that? Yes, because he's the finder of lost goods. Also, if in finding these goods, the amount spent was 2/3 of the total amount. Okay, like for example, let's consider 90 rupees. 90 rupees, 2/3. So 60. So these goods, the MRP was 90 rupees. Okay, but Shiva spent almost 60 rupees in just finding these goods. Now in such a scenario, he can sell these goods even if he is not the owner, because 2/3 amount is spent by him in just finding the lost goods. Okay, yes peoples? Okay, anybody, any doubts? And the last part, when a person who's not the owner, he can sell the good. In case anybody, any individual who gets insolvent, his official assignee, who has been legally appointed, his receiver, he can sell the goods. Okay, and the buyer will get a valid title. The buyer will get a good title to it. Yes, people? Everybody understood? Okay. Anybody, any doubts? Guys, anybody, any doubts? No? All good? All clear? Because this is the next topic that we will be doing, modes of delivery. Okay. Guys, all clear? Yes. So, I'm sure. So, as I told you, easy, no? So, generally, a sale is supposed to be done by the owner, but in certain situations, even if a non-owner does it, it's fine. And we saw those situations. Correct, guys? Easy it was. I told you, it's going to be easy, but it's not going to be as like it's a cakewalk like the way conditions and warranties were, or the way your next lecture, your 8th lecture is going to be. 8th lecture is also very simple. That's the last lecture of Soga. Now, the last part of today's session, but then this is a big part. Okay, so we will be talking about modes of delivery. Now, what do you understand by modes of delivery? Number one, actual delivery, symbolic delivery, constructive delivery. Okay, these are the types of deliveries. This is how you deliver any kinds of goods. Now, what do you mean by delivery of these goods? Okay, now first of all, actual delivery, symbolic delivery, and constructive delivery. Now, this is Mr. A. This is Maruti showroom. Okay, and this is a car. Yeah, sorry guys. But yeah, this is a car. Come on, it looks like the Tarzan car, okay? No, it doesn't. Okay. Okay, so Maruti showroom, it delivers the entire car to Mr. A. So has the actual good been delivered? Yes, the actual good has been delivered. Okay. So this is known as actual delivery. Now there are actual delivery is the simplest kind of delivery where physically the goods are actually transferred to the other person. Now next is symbolic delivery. Now what do you mean by symbolic delivery? Again, now listen very carefully. This is Mr. A. This is Mr. B. Now, Mr. B wants to sell his car to Mr. A. Let me draw the car again. See, it just got better than the previous one, didn't it? So, he wants to sell this car. He is the seller. He's the seller. Mr. A, he's the buyer. So, Mr. B wants to sell this car to Mr. A. Got it, everyone? Mr. B wants to sell this car to Mr. A. Now, when he is selling the car, when Mr. B is selling the car to Mr. A, in such a situation, he doesn't want to go and physically deliver the goods. He's taken the money and he's maybe in a, in an area, he's sitting with his friends, he's chilling out. And that time Mr. A walks in and Mr. A says, give me the car, I'm here to take the car. So Mr. B, he takes keys out of his pocket, okay? Now, key to I can easily draw. Yes. So Mr. B, he takes the keys out of his pocket and he hands over the keys to Mr. A. He take the keys. My society is just right to this one. It's you walk a little and on the right side, my society, you'll see my society. And the car is parked there. You obviously know which car. Okay, so he did not physically deliver the goods, but giving him the keys, will it enable the physical delivery? That is symbolic delivery. It enables the physical delivery of the goods. Got it, everyone? Got it, people? Yes. Next is constructive delivery. Now, constructive delivery, it's a very good example that is given in the books. So Mr. A, he sells to B 50 bags of wheat, which were in C's go down. The ownership was with A, but the possession was with C. Okay, so A, B, and C. So A is the seller, B is the buyer, but whose possession were the goods in? C. So C's possession, C's go down, the goods were in, okay, and A wants to sell those goods to B. Now A, he tells C that I want to transfer these goods to B. C also says, okay, fine, I'll do that. So A tells C that these are the goods that are in your godown. They belong to me. I am the owner. Please transfer it to B. C says, okay. And he writes down in his book that yes, I am transferring this to B. Okay, then after that, of course, B being the buyer and A being the seller, A hands over the order, this entire order to B. Now this is known as a constructive delivery. A delivery that has been done by a third person. That's it, simple. What is a constructive delivery, guys? Very simple. A delivery that has been done by a third person. So here, delivery is done by C. So C is a third person. Correct? So delivery that has been done by a third person on behalf of the owner is known as a constructive delivery. Clear, everyone? Yes, people? Easy? Easy peasy. Okay. Now, what are the rules regarding delivery of good? Now, there are certain rules that you need to remember. In brief, we are going to study these rules. Very simple, very simple. Sections 31 to 44 deals with the delivery of goods. You need to remember that. Section 31 to 44. This is what we will be talking about. Delivery of goods. Okay, now let's see. Number one, mode of delivery. In the contract, we decide that the delivery of goods should be as per this and this, in this prescribed mode. So it's better if the entire delivery is done as per the prescribed mode. Now, it can be actual, it can be symbolic, it can be constructive. But in the contract, when the parties have agreed that the delivery will be as per this particular contract, so the delivery should be done accordingly. Okay, it can also be done by a person who's authorized to hold these goods. Like in case of constructive delivery, it was done by C. He wasn't the owner, but he was authorized to hold these goods. Okay, so that is also fine. That is also allowed. So number one, mode of delivery. Then second, delivery of goods and payment of price. Again, the way it was given in the contract, it should be done as per that. So for example, if we've said in the contract that I will give you the car and pay the price within 10 days, the car should be given and the price should be paid back within 10 days. Okay. If it's done that I will give you the car and you pay me the price immediately, the price should be paid immediately. So the price will be done as per decided. Then next is part delivery. Can we deliver the goods in installments? Of course, yes. Why not? We can deliver the goods in installment. Whenever, for example, we deliver like 50% goods right now. The remaining 50%, can we deliver it? We've decided this as per the contract. The buyer and seller has decided that every 10th of every month you deliver the remaining goods. Okay, and this will be done in 6 installments, 6 halves. So for 6 months, this transaction will be going on, and every 10th, the goods will be delivered. Okay, now. When will this be considered as the whole delivery? Okay, even when a part of these goods are delivered and we have an intention that we are going to deliver the remaining parts as well. Please focus on my words, intention. We have an intention that we are going to deliver the remaining parts as well. Okay, in such a situation, it will be an effective delivery. It will be a valid delivery. Okay. Okay, next. Yes, moving on. Effect of part delivery. Now, what do you mean by part delivery? First of all, I hope you guys have understood the first point, modes of delivery. It can be in the mode, it can be in actual, constructive, symbolic, whatever both the parties have agreed upon. Second, the payment of price can be done as per the agreement of both the parties. Buyer to apply for delivery. Now, for example, let's consider easy examples I'm going to take. Okay. So let's consider this is Mr. A, this is Ms. B, and there was this car. I'm not drawing the wheels now, you understand, okay? This is wheelless car without any wheels, okay? So, Mr. B is this, Ms. B is the seller. Oh, sorry, I forgot to draw her hair. Mr. A is Takla. You understand what takla is? Takla means, okay. So, Ms. B is the seller. Mr. A says that I want this car, but I want this car on Diwali. Okay, a nice auspicious day of Diwali. This is what Mr. A says. Miss B says, okay, fine, of course, I will keep the car ready. You come and you take it on Diwali. On the day of Diwali, Miss B, she kept the car ready. It was all washed and all the papers, everything was ready. Okay, but Mr. A, he did not approach Miss B. Now, Mr. A, after 2 days, he called Miss B and he says, I told you I wanted the car on Diwali. Excuse me, you can't do that. Sorry, Mr. A. Excuse me, you can't do that, because it's a buyer who's supposed to approach for delivery. Who needs a car? The buyer needs a car. So it's him. So Miss B can definitely says, you know what, Mr. A, I'm sorry. It's your fault that you didn't call me up. Okay, so she can she blame him? 100% she can. So it's a buyer's duty to apply for delivery. Okay, next, place of delivery. Place of delivery, of course, it must be decided between the parties as per the contract. But if it is not decided, it should be a reasonable place, like where the goods are produced, where the goods are manufactured, where the goods are in existence. Okay. Then next is time of delivery. Time of delivery, again, there is if the specific time is decided by the parties as per the contract, of course go ahead with it. If there is no specific time, you need to have a reasonable time period. Then next, if goods are in possession of a third person, I've already explained this to you in constructive delivery, just the same concept. Okay, the only thing is, you remember in constructive delivery, here A, B, C, A was the seller, B was the buyer, C was the third person who was in possession of these goods. So until and unless C should acknowledge that yes, I am in the possession of the goods on behalf of A, only when he acknowledges it, this sale will become valid, this transfer will become valid. There should be an acknowledgement. Okay. Now next, cost of delivery. Who will bear the cost of delivery? Cost of delivery, guys, okay, now let me tell you. So this is Mr. A, this is Ms. B, buyer and seller. Okay. Now, black is better, no, guys? The black pen, this is better, no? Okay. So Mr. B and Mr. A and Mr. B, these are the goods that they are trading in. Okay. Now what happens? So Mr. A says, I want to buy these goods. Okay, Mr. A, he is the buyer of these goods. Ms. B being the seller of this goods, so obviously she is the owner of this goods. Okay, now Mr. A says, Ms. B, let's consider she stays in Kerala. Kerala, it's called as God's land. I definitely want to visit Kerala. I've never visited Kerala, and yes, I want to some or the other day. That's honestly my father's favorite place. He often talks a lot about it. Okay, moving on. So now, Miss B, if we talk about she being in Kerala, she said, and Mr. A, he was in, let's consider UP, Uttar Pradesh. Okay, and he had to take these goods to Assam. Not Assam, Assam is too far. Let's consider Kashmir. He had to take these goods to Kashmir. So now, Miss B says, I will get these goods till UP. I am from Kerala and the goods are also in Kerala. So the goods will be delivered till UP. So whatever expenses Kerala to UP for delivery of these goods will be borne by Miss B, the seller. But after that, once the goods have been delivered to UP airport, okay, let's consider the goods were delivered on the airport. Once they've been delivered, all the further expenses, till you wanted to reach Kashmir, you wanted to reach anywhere else on this planet, all these expenses will be borne by the buyer. Okay, this is how generally it's done until and unless the parties have agreed to something else in the contract, but this is a general provision. So this is how the cost is borne. Now delivery of the wrong quantity. Now what if? The order was for 200 units and only, let's consider 170 units were received. Now what will happen? What will happen in such a case? We had ordered for 200 units and how much did we receive? 170. Is it a wrong quantity that we received? Absolutely. Now what options do we have? Either return the entire order. Okay, entire order, you can return it. Return entire order, number one. Number two, pay for 170 units, the wrong quantity that we've received, pay for 170 units and finish the order. Okay, or else you can also demand the remaining 30 units if needed. Okay, so these are the options that you have. Now, another circumstance, another situation, you ordered 200 units, but you received 220 units. Now, did you receive extra? Yes, but still, is it wrong quantity? Absolutely. So, it's wrong quantity, so you have the rights to return the order. So, return the entire order. But ma'am, we've received, no, we ordered 200 units, we received 220, we've received more than that only. Yes, but you received a wrong quantity. You had placed an order for 200, you received it for 220. Okay, so you either return the entire order, number one. Number two, you accept the entire order, that is of 220 units, and you pay also accordingly. Okay, so pay for all the 220 units. Or else the third one is, you accept the original order of 200 units, you pay for these 200 units, and you return the remaining 20 units. Got it? These are the options you have when you receive a wrong quantity. Got it, everyone? Clear, everyone? Yes? Anybody? Any doubts? All good? All there? Okay. Now, installment delivery. Now, when both the parties have decided that the delivery will be done in installments, fine, no problem, you can do it. But when the parties had not decided something like that and the delivery was done in installments, you can reject the entire delivery. Okay? Then delivery to carrier. We've already covered this part. Whenever you deliver goods to the carrier, okay, and here you are delivering these goods with an intention that these goods are going to reach the buyer. So it is assumed that the ownership, the property has been transferred. Then next is risk where goods are delivered at a distant place. Now when goods are delivered at a very far away place, so obviously this will be done on buyer's demand. So the buyer will bear the risk of the goods being delivered at a long distance place, because obviously who will demand that the goods should be delivered at such a long distance? A buyer. Okay. And last is, guys, remember, when the goods are delivered to the buyer, he needs an opportunity to examine the goods. He needs that space to examine the goods. If you expect him to accept the goods without examination of the goods, no, that is not okay. That will not be done. Okay, so you need to have the right, as a buyer, you need to have the right that I will first examine the goods, because I need to see if they are as per description, if they are as per sample, if they are as per the contract. I need to examine that. If they are as per specifications, fine, fair enough. If they are not as per specification, I have the right to reject these goods. But I need to be given an opportunity. You cannot deny me of that opportunity. You cannot tell me as a buyer, accept the goods. I've sent it, accept it. No, I need to have a sufficient opportunity of examination. Clear, everyone? Yes? Okay, and that's it, guys. That's it for today. So there were two topics that we did. Number one, it was about, second one that we did was about mode of delivery, which was very important. And at the same time, it was easy. It wasn't that difficult, right? Okay. And the first one that we did in today's starting of the session, we covered the transfer of property by non-owners. Okay, so these are two different kind of topics that we covered in today's sessions. All clear, everyone? Yes. So, because this is almost like the second last lecture of SOGA. SOGA is about to get done. In the last lecture, we talk about unpaid seller. Easy peasy part, but not easier than today's session. Okay, in fact, it's the difficulty level is a bit more than today's session. But please tell me, how much have you guys enjoyed SOGA? We have had like we'll be having 8 sessions of SOGA, and the entire thing is going to be finished. Nothing other than these sessions will be covered. Whatever we'll be covering in these 7 sessions, nothing beyond this will be asked. Trust me when I say that. You attend these 7 sessions, you see it like twice or thrice, increase the speed and see it maybe, but then just see it, you guys are done, you guys are through. Okay, SOGA will be done, and SOGA is for 20 marks. Yes, okay, so we need to secure as many marks as possible here. So yes, guys, that's it. We will stop for the day. We will stop for this cute little session. It was a nice and sweet and a small session. And I will see you people in the last session of SOGA very, very soon. Okay? Till then, everybody take care of yourselves, stay safe. And yes, I am CS Kajal Hande signing off. We'll see you guys super soon. Take care, everyone. Okay? Stay safe and study well. Bye-bye, guys.